Or got it. All right. Well, thank you all for joining. I was going to say we can do just a quick round of introductions so that we know who's who and where you're coming from and what your interest is. We've kind of already done that with our smallish group, but I'm John Bennett with the Windham Regional Commission. And my primary focus these days is municipal planning and municipal planning assistance. I guess I'll leave it at that. And why don't we run down the WRC staff? Margot?
Hi all, my name is Margot Gia and I am the Natural Resources and Energy Planner.
And Colin?
I'm Colin Bratton. I do transportation stuff for the Windham Regional Commission.
That's a good way to put it. All right, Jane, you were the first one on.
Jane Douglas, I'm a planning commissioner for the town of Newfane. I've been on the commission bit over a year now, so still feeling my way around the processes.
All right, well, welcome, and I hope we'll share some enlightenment with you. And Peter?
Peter Maris, Whitingham. I'm on the planning commission there.
All right, thank you. And Laura Katz, I don't know if you can hear us, but we're just doing a quick round of introductions. What your name, we know that, what town you're from, and what your perspective is. Maybe Laura can't hear us. Or is muted, and I don't know, I don't think I can unmute her, so I'm not going to try. All righty. I'm going to give a very brief introduction to this evening's festivities. And I'm going to start by attempting to share my screen. Share screen. And I want the PowerPoint. Share. There we go. All right. So, basics of town planning. With my advance apologies that we have 40 slides. So, I'm going to try to be expeditious. It's broken into 4 sort of chunks: planning, plans and planning, roles and responsibilities, who you can read what it says, implementing the plan, and then meetings, hearings, and due process. We have a break for questions in between each section. So we'll have plenty of opportunity for you all to ask questions and us to try to answer them, and same at the end. But if you have a burning question in the middle, I guess we're a small enough group, you can just holler out. But I was going to say, if it were a larger group, we'd ask you to put them in the chat, and Margot will be monitoring that so that we can get to them during the break for questions.
So John, before
Yeah.
we get to that, Laura just wanted to mention that unfortunately she can't figure out how to unmute, but she is from Weston.
Oh, okay.
And we already have a quick question, and that is from Peter.
Yes.
Oh, yeah, I was just typing it. Would you send us the slide deck?
Yes.
That'll save me a lot of screenshotting.
Oh, yeah, no, we will send you, we'll be very happy to provide you the slide deck.
Great, because one of the things Whitingham is on about is that the commissioner is supposed to report.
Alrighty. Well, I will be happy to. You're not asking me to send it right now, are you?
No.
Phew, okay. All right. Let's see. Laura Katz. And we have Lester. We just did a quick round of introductions, just who you are and where you're from and what your interest is.
Well, I just joined the Planning Commission in Grafton. I've been living off and on in Grafton for a couple of decades, and now I'm trying to be of some use.
Awesome, wonderful. How good of you. We applaud your civic service.
Well, certainly, talk to me later, but let me say this: I'm fascinated with this, and I'm really looking to learn. So this was it seemed to be an excellent opportunity to get some handouts already.
All right, wonderful. All right, well, just for Leslie's benefit, this first slide is the outline of what we're going to try to get through. There are 40 slides. My apologies for that many, but there's just a lot there. And we have a slide break for questions in between each of the sections and at the end. So also, if you have a question, you can put it in the chat. Margot Gia from WRC is going to be monitoring the chat so that I can have single-minded focus on trying to share information. And with no further ado, let us proceed. So general context, Vermont's a Dillon's rule state. A lot of folks think it's a home rule state, but it's not. It's a Dillon's rule state, which means that towns can only do things enabled by statute. And if you're going to do them, you have to do them as specified by statute. And what the particular statute is Title 24 of the Vermont Statutes Annotated, Chapter 117, Sections 4301 to 4498. The formal name is Municipal and Regional Planning and Development Act. It's often called the Act, the Development Act, or Planning and Development Act, but that's its formal title. Three sort of essential elements of land use planning and regulation. There's a statute that authorizes town plans and the implementation of them. The plans are authorized by statute with specific required components, and implementation tools are both regulatory, such as zoning or flood hazard area regulations or subdivision regulations, and non-regulatory. And we'll be getting to slides on each of those a little bit later. General history of Vermont land use planning. In 1921, legislature authorized towns to create planning commissions that could draft municipal plans. 1931, legislature first authorized zoning regulations. In 67, the Chapter 117 that we'll be talking about was first enacted, included purposes of planning and zoning, and specified required contents of and adoption processes for plans and zoning. And in 1988, there was Act 200 that updated the planning portions of Chapter 117, listing state planning goals and required elements of plans, all of which we'll get to in a little bit. And then 2004, Act 115 incorporated additional updates to the zoning portions of Chapter 117, the substance and the process. What's a town plan and why have one? What it is document defining community's vision for the future and providing guidance for achieving it by means of various mechanisms. It essentially provides policies to guide orderly growth and development. And why do you have it? To develop a community-wide vision. And the plans empower the town to respond to change in ways that reflect its shared values, goals, needs, priorities, and provides a way to designate what you'd like to see where, conservation and development. And if you're interested in maintaining things as they are or letting them evolve over time or to transform more quickly, provides guidance for that. There are a number of benefits for having a current and adopted town plan. And we'll get to current, but basically town plan has an 8-year expiration date. Anyway, town can, with an adopted plan, the town can adopt and amend zoning, subdivision, and flood hazard area regs. If your plan expires, you can't amend any of those. They don't go away, but you can't amend them. And in Act 250, an Act 250 permit can only issue with the District Environmental Commission or the Environmental Court or the Natural Resources Board, finding that the proposed project conforms with the town plan. And similarly, in Section 248, petitions for certificates of public good to the Public Utility Commission, recommendations of town plan are given due consideration or, in some cases, substantial deference. And we can talk about that in a little bit, but substantial deference means that if the town plan has a presumption of carrying the day, I guess, in evaluating an energy generation or transmission project, unless the Public Utilities Commission decides otherwise. Whereas, and that's if you have a determination of energy compliance for an enhanced energy plan pursuant to Act 174. An approved plan is necessary to satisfy eligibility requirements for certain state grants, like municipal planning grants or a number of others, or state designations, such as a designated downtown or a village center. And we'll get to what approved means in a little bit, but that's Regional Planning Commission approval of plans. The planning process generally, you adopt a plan or you have adopted plan, you try to implement the plan. Along the way, over the course of the 8 years, you evaluate the plan and the planning program and collect and analyze background information, review and establish goals and objectives, outline policies and actions to achieve them, and then create an implementation program, adopt the plan and implement it. So circular. Statute lists 4 general process goals, 14 specific planning goals. These are important because a town plan has to be consistent with the state's planning goals. I don't think I need to read each and every one of these, or if you'd like me to, I can, but establish coordinated comprehensive planning process, encourage citizen participation, consider use of resources and consequences of growth and development, and encourage and assist towns to work creatively together to develop and implement plans. There are the 20, these are paraphrasing of the 14 specific state planning goals. So I am not going to read my way around the circle and put you in a coma, but there's a lot of opportunity here, shall we say. Encouraging citizen participation is important in the planning process, and there are various means to inform citizens, the community, and consult with them about existing ideas, listen and acknowledge concerns, answer questions, involve community in providing opportunities for dialogue and interaction, and collaborate with them, with the community, partner with them with the public in decision making. And there are various mechanisms, all with the little stars next to them. So it's your town plan, but there are 12 required elements specified in statute, and there they are. They're listed in what seems like random order, because you would think that you would have recommended program for implementation either at the beginning or at the end, but the reason they're in this order is because the legislature keeps adding new requirements. So after it had required the first 7 or 8, then it added an energy plan, and then housing element, and then economic development, and then flood resilience plan. And they didn't renumber the stuff in statute, they just tacked it on at the end. So most town plans have them in a more rational order, with things like the implementation plan coming at the end after you've gone through all the other elements. Town plan adoption. They expire every 8 years. It's a really good idea to update, revise, or readopt the plan before it expires for all those reasons I talked about in the previous slide, all the benefits of having a town plan. And a heads up, the adoption process takes a significant amount of time. Just for example, if everything went perfectly smoothly, there has to be a planning commission hearing on a draft plan, and that has to be sent out 30 days in advance to adjacent towns and other parties, including the Regional Planning Commission and the state DHCD. Then after the Planning Commission hearing, they have to submit the plan to the select board, who have to have a hearing, and that's not less than 30 days after the PC submits the plan to them. And at least 1 hearing is required in rural towns. 2 are required in so-called urban towns with a population greater than 2,500. But there's 2 full months if everything went perfectly smoothly right there. So we try to encourage towns to get after updating their plan a 1.5 years or 2 years before its expiration date. The adoption of a plan is by vote of the select board, unless the voters of town have elected at a regular or special meeting to vote on adoption by Australian ballot. That makes the process even more cumbersome. And there's usually, towns are often in a time crunch to get a plan adopted before it expires, get a new plan adopted before the old one expires. So there's at least that one good reason to keep it at a majority vote of the select board. And plans go into effect immediately upon their adoption. I had mentioned that Regional Planning Commission approval of a town plan and confirmation of the town's planning process. You don't have to do that, but you may request approval of the plan and confirmation of the process. But that confirmation of the process is important for being eligible for those state designations, village centers, and so on, and for applying for grants like municipal planning grants or bylaw modernization grants. The Regional Commission shall approve a plan if it is consistent with the planning goals established in statute and is compatible with the regional plan, and is compatible with the approved plans of other towns in the region, and contains all the required elements specified. And then there's the planning process confirmation. Commission shall confirm the planning process if the town, and there are only 3 bullets here, but there's a 4th one that's sort of silent, but is engaged in a continuing planning process that will result in a plan consistent with the planning goals, is engaged in a process to implement the plan and maintaining its efforts to provide local funds for municipal and regional planning purposes. Those are 3 bullets in statute. Buried in the bottom of a paragraph that follows those bullets is, and also, in order to get confirmation, the town has to have an approved plan. So we go through a convoluted process when we review it. First, we review a plan and then approve it, and then we have a separate vote to confirm the planning process contingent upon the plan being approved. Sorry about the weeds, but I can see Jane shaking her head. Oh, That's why you have a guide. All right, break for questions. Anyone want to ask a question?
Yeah, I had a question. What exactly constitutes planning? You might be getting to this, but what exactly constitutes a planning process, and what would lead to a planning process being confirmed or not confirmed?
Well, we revisit this slide and we can talk about it a little bit more, but municipal planning process, the town has to be engaged in a continuing planning process that will result in a plan consistent with the planning goals. So that consistent with the planning goals essentially means that you're not running counter to the goals and are actually trying to make progress towards achieving them. And continuing planning process means the town has a planning commission that's aware of its town plan and keeping an eye on it, and the town is trying to implement the plan, which is the next bullet. And then maintaining its efforts to provide local funds for municipal and regional planning purposes. So they have to be providing some form of a budget for the planning commission. It's often not a great deal. Some towns are more generous than others. And they have to contribute to the Windham Regional Commission. We have a town assessment that's based on a per capita amount. It's not a great deal. I think if you ask most towns, they'd say they get more than adequate benefit for that per capita assessment fee. Does that kind of answer the question? Yeah, Jane, do you have a question?
Well, I was curious as to what is engaged in a process to implement its plan. I mean, does that mean you have to be actively working to make some goal in the plan happen all the time?
Well, it means that over the course of time, there should be some evidence that the town is trying to achieve what the plan says. So in, I want to say, Newfane's case, for example, there's an ongoing, currently, well, let me back up. There was something in the town plan that said we should designate village centers. And so the town did pursue that, and now you have designated village centers in Newfane and Williamsville and South Newfane. So there's progress implementing the plan. Similarly, I suspect, though I don't recall really clearly, that there was something in the plan about pedestrian traffic in Newfane Village, and the town applied for and has a grant now to investigate, and Colin can speak to this in far greater detail than I, but to investigate improving sidewalk and pedestrian getting around in the village. So does that answer?
John, so I have a question again. Forgive my really naivety. So I certainly all the advantages of planning and thinking and getting the town, the community to think together about all these things are obvious and make a lot of sense. But is the real carrot only? I mean, what is the carrot? Is that if without a plan, one doesn't have access to all of these grants, et cetera, that the state sort of incentivizes the towns to do this by saying, if you don't have it, you can't get certain funds?
Well, to a limited, I guess a somewhat limited extent, though it's not all that limited. Because in addition to the grants that I mentioned, the planning grants, there are also, I'm pretty sure, for better connections grants funded by VTrans, that you also have to have a town plan and maybe even a confirmed planning process. But in broader terms, for almost anything that you want to do, for example, in Grafton, if you were trying to look at the possibility of community wastewater facility or community water supply, when you go to write a grant, if you can point to a town plan part of your town plan that says it's the town's intent to do this, that makes it a far more compelling grant application.
I see. But you couldn't, it would sound like not having it would prevent you. That's it. But in the meantime, I see. I didn't realize that. I thought it was somehow or another that was their only carrot was saying if you didn't have a plan, you couldn't get funds. But
I would almost call that a stick rather than a carrot, but
yeah, it could go either way. You know better.
anyway, no, but plan enables you to go after all sorts of things. I know several of our towns are looking into community wastewater and or water supply. And it's very, very much more competitive application for funding if your town plan says you want to do that.
Yeah. Thank you. Okay.
All right. Any more questions before we move on to the next section?
All these grants that you can apply for, I mean, how do you know what grants you can apply for? Like, if we wanted to build a water tower in the middle of Newfane, would there be such a thing, or do we even know what kind of grants we could get for doing that?
Well, there are various resources. The first one I would point to is your Friendly Neighborhood Regional Planning Commission. Sue West, our community development staff lead, has a pretty good ongoing list of possible grant funding stuff. You can see it. I think it crops up in our newsletter, our sporadic, but usually quarterly or maybe slightly more frequently newsletter. But you can also reach out to Sue either through our website or on the phone. There are also other sources of information, but I think Vermont League of Citizen Towns could be of assistance there, and various state agencies. ANR, the Agency of Natural Resources, has, I can't remember the name now, their divisions names keep changing, but they have a whole division devoted to wastewater planning and funding, or water supply planning and funding. There's a state revolving loan fund for each. So there are sources of information, and we could be a good first step in helping you try to find them. Any more questions? And this isn't your last bite at the apple, so. Alrighty, well, trying to move on slightly expeditiously. Local roles and responsibilities, and who does what, as defined by statute and delineated by function. So there's three sort of functions: legislative, which is really, in this instance, meaning you're writing things like plans and adopting things like plans. And then there's quasi judicial, which is if you have land use regulations, and many of our towns do, even though they may not have zoning. For example, Grafton has flood hazard area regulations, but not regular zoning. Anyway, there's a quasi judicial, that would be, in Newfane's case, the DRB, reviewing permits to see whether they should be permitted or not, conditional use permit or site plan review. And then there's the administrative side, which would be your zoning administrator, who takes in permit applications and either issues a permit or denies it, or refers it to what will be called the appropriate municipal body, which is whoever performs a quasi judicial review. So slightly amplified. So legislative body, the select board, and then they, under them, there's a legislative side, the planning commission, where they write draft plans or draft bylaws. And then the quasi judicial function, which is either a development review board, or if you don't have a development review board, then it's a zoning board of adjustment and a planning commission, which share things. And we'll get to a slide on the shared stuff. And then on the administrative side, which is the zoning administrator. So legislative functions. Planning Commission drafts a town plan, drafts zoning and other land use regulations. It may prepare or edit a capital budgeting program, though select boards are usually pretty protective of their turf in that particular line. And the Planning Commission can prepare other studies or hire them done if they can find funding to do so. And then the select board, it reviews and may edit the town plan. They take the town plan as provided to them by the Planning Commission, and they can edit it however they want, and then they can either adopt it or reject it, or if the town's voted to have it adopted by Australian ballot, that goes to the voters. Similarly with zoning bylaws and other land use regulations, select board reviews what the Planning Commission sends to them, and they can edit it, and they can either adopt it or reject it, or in the rare case where, and I can't think of a town in our region that does it this way, sends the bylaws to voters for adoption by Australian ballot. And the select board prepares or edits and adopts the capital budget and program. Quasi judicial functions. So if you have a DRB, they review all of these things, including hearing appeals of the zoning administrator's decisions or actions. If you don't have a DRB, then the way statute was set up, planning commissions review site plans and subdivisions and lots without adequate frontage, while a zoning board of adjustment reviews conditional uses and variances and appeals of zoning administrator decisions. The reasons for having a DRB are that it frees the planning commission up from doing reviews and allows them to focus on drafting the plan or drafting bylaws. In the administrative function, the ZA issues or denies zoning permits, conducts enforcement, assists applicants, and in many towns provides staff support for the DRB, the Planning Commission, or the ZBA. Well, so that was a quick romp through roles and responsibilities. Any questions folks have? Oh, wow. All righty. Well, so implementing the plan, there are two sort of main mechanisms. One's regulatory implementation, where you may have zoning and subdivision bylaws. You may have flood hazard area bylaws. There's also local ordinances, and we'll get to a discussion about the difference between ordinances and bylaws in a minute, but they essentially have the same effect, but they're not identical. And then there's non-regulatory implementation, improving public facilities, informing, engaging the citizens, developing supplemental plans, a housing plan, or other things, or pursuing protection of important resource areas by working with a local land trust or something. Bylaw or ordinance, what's the difference? They have similar impacts, but are adopted and may very likely be enforced differently. Bylaws and regulatory tools governing land use are generally adopted and enforced under Chapter 117, and that includes zoning, subdivision, and usually flood hazard area regulations. But towns can also adopt ordinances under Chapter 59, adoption and enforcement of ordinances and rules. That is a very different process. Chapter 117 requires all those public hearings and stuff before you can adopt things. Under Chapter 59, the select board can just adopt something. Then they publish it, and citizens have a limited amount of time to petition to vote to overturn the adoption. That has happened in a couple of our towns. So, or at least one that I can think of in recent history, relatively recent history. So they're very different in terms of their route to adoption. They didn't have, select board doesn't have to have a hearing on the ordinance. They just have to put it on their agenda and wham, they can adopt it. And ordinances are for any of a huge number of purposes authorized by law. Everything from dog ordinances to junk ordinances to traveling salesman ordinances. There's a huge list in chapter 59. And ordinances may be enforced under the Judicial Bureau of the court system as civil or in Superior Court as criminal, or they may be enforced under Chapter 117, which is generally speaking a longer and less strict process, I guess I'd say. Why would you have local land use regulations? To implement the town plan, to promote compact walkable development, protect resources, minimize fragmentation of farmland and forest, facilitate affordable housing, encourage efficient use of infrastructure, compatibility with historic character, ensure safe vehicular and pedestrian circulation, and make the community more flood resilient. There are limitations on local regulations. You can only regulate what's enabled by statute under Chapter 117. Must comply with required provisions and prohibited effects, and also with another section, limitations on municipal bylaws. And I won't go into the weeds on these right now, but there are a fair number of provisions in each of those sections that you have to abide by. And in more general observation, land use regulations tell people what they can and can't do with their land, but can't deprive landowners of all reasonable use. Participants and processes potentially involved in local land use regulation. So starting from the left, the ZA receives an application, and it may be something that he or she can permit because it satisfies all the requirements of the bylaw, and they issue a permit, or if it doesn't, they deny a permit, and presumably would refer it to the appropriate municipal panel, the DRB or the ZBA/PC. Zoning administrator actions and decisions are appealable to either the DRB if you have one, or to the ZBA if you don't have a DRB. If the zoning administrator receives an application, takes a look at it and says it needs a permit, a conditional use permit, or something else, refers it to the appropriate board, the DRB, the ZBA, and or the planning commission, and then the panel holds its hearing and issues a decision, and there's an opportunity to appeal a decision of the appropriate municipal panel, the quasi-judicial panel, to the court. And I think I'm going to get to another flow chart about that in a minute. So local regulation, the types of review. There's a definition of land development. I'm not going to read every element of it, but it includes subdivision of land, and it includes changes to construction or changes to buildings or structures. It includes mining, excavation, or landfill, and any change in use of a building or land or extension of the use of land. So the types of review under zoning. There's the permitted use, which is allowed by right if it meets all the requirements, or a conditional use, which may be allowed if it conforms with the standards that have to be provided in the bylaw. And there's site plan review to try to ensure a good site design and compatibility with the neighborhood and so on. There are variances, which are departures from the standards in the bylaw, but those have to meet very stringent statutory requirements. There's actually 5 specific findings that all 5 have to be made for a variance to be granted. Many towns were issuing those under the, I don't want to say guise, trying to provide common sense, but they were not actually issuing variances for projects that met all 5 of the statutory criteria. And so if those were challenged, they probably would not survive a legal challenge. And the legislature, in its wisdom, enacted a provision for dimensional waivers to allow flexibility in local dimensional standards. You don't have to meet the 5 very stringent statutory requirements of a variance to achieve a waiver. But the town has to have provision for waivers in the bylaw. Then there's planned unit development that allows for flexible design and modified standards. You can cluster things, or you can have mixed uses and so on. And then subdivision controls the pattern of future development and also pays strict attention, or most times does, to providing sound infrastructure, road standards and drainage standards and so on. Regulatory decisions. The requirements are, among others, that they have to be issued in writing. They have to include a statement of the factual basis on which the panel made its conclusions and a statement of the conclusions. Must be based on review standards contained in the bylaw. Minutes of a meeting may suffice if they provide all the necessary information. See the bullets above. And then there's a timeline. The quasi-judicial panel has to have a hearing and adjourn the hearing and issue a decision within 45 days after the adjournment of the hearing. If they don't act within those 45 days, the application is deemed approved and becomes effective, permitted on the 46th day. Should note that adjournment of the hearing doesn't have to be the first session of it. You have a hearing and there's not enough information to make a decision, you can recess the hearing to a time and date certain and then reconvene it. And that sometimes happens multiple times before there's enough information in hand to actually make a decision. So the takeaway, one of the takeaways is the decision does not need to be made the day of the hearing. You can have your hearing and close it and then have a deliberative session, and we'll get to that in a minute, to actually contemplate what you've heard and how you want to decide. Appeals under 117 of the decision or act of the administrative officer, appeal goes to the DRB or ZBA. A decision of the board, the appeal goes to environmental court. Interested persons may appeal, and there's a very specific definition of what constitutes an interested person. I'm not going to try to read through all of it, but it interestingly includes agency of commerce and community development and any department or administrative subdivision of the state owning property or any interest in property within a town. Only interested persons who have participated in a hearing may appeal. And making the decision on who's an interested person or not. Something the town board can choose to do, but it can choose not to get into that can of worms and leave it up to the environmental court to make that decision. Non-regulatory implementation. So here are, among other things, what towns can do to try to implement plans in a non-regulatory fashion. There's capital budget and program, tax stabilization contracts, purchase or acceptance of development rights, supporting plans, you know, a housing plan or what. Advisory commissions. You can have a housing advisory committee, or in many cases, it used to be, that's what conservation commissions were. Now they're statutorily authorized. And then other projects and studies, whatever the town plan recommends. Now, you guys ask some questions so I can have a sip of coffee.
I got one.
I know I could count on you, Peter.
Well, it says capital budget and plan a couple
Yep.
of times in this whole list.
Yep.
Whose money? Who's deciding what to do with whose money in that case?
That is the town deciding what to do with the town's money. That would be, in most cases, in fact, it is the select board adopting a capital budget and program. Now, they usually would have, for example, significant input from the highway department. You know, we're going to need to replace our 40-year-old road grader within the next 10 years. So we should be having a capital program that includes buy a new grader in 5 to 10 years.
Okay, got it. Yeah. Thanks.
Yep. Come on, another question. Jane.
How do you decide which way to go, whether you make it a bylaw or an ordinance? I mean, is there some level of impact that matters, or?
I guess one takeaway from what I have observed is that you have a much greater chance of achieving community support and buy-in if you follow the Chapter 117 route, where Planning Commission has a hearing and they hear what people's concerns are, and they usually try to address them, or at least answer the question. And then it goes to the select board and they have a hearing. So there's another chance for community input. So that by the time it actually gets to a vote, there have been at least 2 opportunities for the public to weigh in. Whereas if you adopt an ordinance under Chapter 59, while it's sort of immediate gratification, is in the select board can adopt it right then and there, that can sometimes set people's hackles up and incite opposition. We've seen that happen relatively recently in a town that shall remain nameless, but tried to adopt flood hazard area regulations. And while there seemed to be relatively broad support for it in sort of general terms, when it suddenly got adopted under Chapter 59, there was a sudden rising of incensed opposition that led to a petition to overturn the vote. Does that answer your question?
Still seems a gray area, but
Well,
I mean, I guess I'm trying to get a feel for what is the impact of something. Like, say the town of Newfane wanted to ban anybody painting their house purple around the common. You know, is that the kind of thing? I don't, just as an example, nobody's doing, but it would be easy and quick for the select board to say nobody can paint their house purple around the common.
Yep, it would be.
Whereas
it also might incite some opposition to it. but,
Hmm.
you know.
Somebody might start painting.
I guess I'm trying to find some level of impact. Painting your house purple around the common would only matter to the houses right around the common and not to the rest of the town. So I guess I'm trying to judge, is there some level by which how many people would be impacted by the change that weighs the
I
decision?
think that's an interesting example. In most instances, ordinances, and I'm not an attorney, by the way. I should have prefaced all of this by saying I'm not an attorney.
Oh,
If you have questions that require a legal opinion, then I suggest you contact town council or Vermont League of Cities and Towns. But that having been said, most ordinances of which I'm aware are town-wide things. That town that tried to adopt flood hazard regs as an ordinance, regulation of junkyards and so on, aren't generally limited to a specific area. Whereas zoning, you may well have distinct districts. So I'm just thinking through this, and I don't have a seasoned opinion to offer you, but it would seem to me that you might well be better served to pursue it as a bylaw under chapter 117 if you wanted to ban painting of houses purple in Newfane Village.
now please, let's hope nobody paints their house purple.
Oh, me. That would be funny. Okay, any other questions before I try to advance this along? Meetings and hearings. Oh, good. So there are different things that are all public meetings of some form or another. So generally, meetings, business meetings, select weekly or bi-weekly select board meetings, planning commission meetings, DRB meetings, any public body that makes decisions has public meetings. Legislative hearings are limited, in this context, the purpose is to receive public comment on a proposed plan or bylaw. And who holds legislative hearings? The Planning Commission and the Select Board. Planning Commission on their proposed draft of a plan or a bylaw, and the Select Board on the proposed plan or bylaw as it's been submitted to them from the Planning Commission. Then there are quasi-judicial hearings, and that's for the appropriate municipal panel to hear parties in the public regarding a proposed project and how it meets the regulations. And who does it is the Development Review Board or the ZBA and or Planning Commission that's reviewing the proposed development. Open meeting law. So all those meetings have to comply with the open meeting law. And that includes posting advance notice, making the agenda available before the meeting, and you have to post it in or near the town office and at least 2 other designated places in town, and on the town website if the town has an official one. Surprisingly, we do have a town or 2 that doesn't have an official town website. One town we have proudly calls the website where they post stuff the unofficial website. Anyway, the purpose of it all is to let the public participate. You have to let them participate, and you have to make the minutes available within 5 days. And you have to address any complaints of violation of the open meeting law. And then this rather important note there are changing COVID-related provisions, and I'm only going to mention one of them, but there are a number. But the one is that under the open meeting law, you had to have, under the regular open meeting law, you had to have public meetings in a defined place. You had to say where the meeting was going to be, and you had to staff that meeting place. When COVID hit under the governor's emergency order, that there was a provision that allowed for you to have a virtual meeting. So you didn't have to have a physical location and staff at that physical location. You could have a virtual public meeting. That provision was expiring after the governor lifted his emergency order, but the legislature enacted a subsequent provision that allows for a continuation of the virtual or hybrid meeting at least until February of 2023. But that's going to change. So you need to sort of pay attention to changes to the open meeting law, as I'm sure Peter is well aware. Anyway, one useful, very useful resource is VLCT, the Vermont League of Cities and Towns. They have a whole raft of stuff on open meeting law, of resources pertaining to the open meeting law and frequently asked questions, and then COVID-related frequently asked questions. So I'd encourage you to check them. The public notice requirements are different for public meetings versus legislative hearings versus quasi-judicial hearings. So for regular meetings, you have to have your notice posted in or near the town office to other places at least 48 hours before the meeting. But there can be special meetings which only need to have their notice up and an agenda available 24 hours before the meeting. And then there are emergency meetings, which you just have to make that information available as soon as possible. There isn't even a 24-hour requirement. For legislative hearings, preparation and adoption of plans pursuant to these sections of statute and bylaws pursuant to these sections, you have to post 15 days in advance to a newspaper of record and posting in 3 or more public places, and by certified mailings or email with receipt acknowledgement. So that's an improved situation, because it used to be very expensive to do certified mailings with return receipt requested. You can now email the notice out, but you have to have some sort of way to document receipt thereof. Sometimes you can do that as part of the email you send out. Generally, we encourage folks to make it a specific request in the email you send out, saying, please respond to acknowledge receipt of this document. For quasi-judicial hearings, for development review, it's either 7 or 15 days notice. I'm not going to get into the weeds about which, but for site plan review, it's only 7 days, whereas for conditional use, it's 15 days, those kind of distinctions. So you need to pay some attention to that. And it goes to newspaper of record and posting in public places and mailed to applicants and adjoiners. Though I do believe, though I'm not 100% certain, you can also do, well, I'm not even going to go there. I'll stop there before I speculate and speculate possibly wrongly. And it has to be posted within view of the nearest public right of way. So here's the ideal flow of a quasi-judicial public hearing. chair opens a hearing, applicant presents a proposal, board members ask questions. Then you have comments from the interested parties and the public. And then the chair closes the hearing and opens deliberations, which can be public or private, and they don't necessarily have to be open right then at the close of the hearing, as we'll get to in a minute. You can have a deliberative session at another time. And then the board decides on the application and issues its written decision. So deliberative session, exempt from the open meeting law, no requirements for notice or minutes, maybe public or private. And you don't have to reveal how the board members voted. And the board has 45 days to issue a decision from the close of the hearing, not a subsequent deliberative session, but from the close of the hearing. So it's important to keep that time frame in mind. In summary, protecting due process, provide public proper notice, give people opportunity to be heard, conduct orderly proceeding, ensure proper management of evidence, and appropriate management of conflicts of interest. And so additional resources. A very valuable one is VPIC, the Vermont Planning Information Center, at that address. And there are documents available, essentials of local land use planning and regulation, a very valuable tool, the plan and bylaw adoption tools. It's one document about 20 pages long with checklists, 2 checklists and report forms. One is checklist for town plans and all the various steps you need to chase through the adoption process, including the planning commission hearing and the mailings you have to do and so on. And then report forms, because something that we didn't mention is, but in the stuff that has to go out from the planning commission to the adjoining towns and other parties in advance of their public hearing is a planning commission report on the proposed plan or bylaw, which can sometimes be overlooked, but is actually an important legal part of the process. And then there's a rules of procedure and ethics manual. So again, more information available at VPIC. There are other sources of information. You can, and this is something that I am always doing, go to the state statute and look it up and read it carefully. You can also contact your friendly neighborhood regional planning commission. Yours truly or any of our staff will be overjoyed to try to assist you, answer your questions, or provide assistance. Vermont League of Cities and Towns, I've mentioned them a couple of times. They have a wealth of information that they can share. They have a municipal assistance center. They can provide legal opinions if you request them. Then there's Department of Housing and Community Development. It's within the Agency of Commerce and Community Development. And they also have a bunch of useful information, including an update of the planning manual. And here's my contact information. And always happy to hear from folks. So don't hesitate to reach out. As I said earlier, this is not your only bite at the apple for getting questions asked and hopefully answered. So a couple of things. I'll take questions on anything we covered. Would take suggestions for future training topics, and also workshop evaluations. Hopefully Margot's posted something in the chat that we would appreciate very much if you filled out as to the content of this evening's festivities. So back to the top. Any questions folks want to ask? Oh, you're muted, Lester.
Thank you. Sorry, John. So that really was very helpful and cogent. But tell me, when does, maybe I missed it, when does one for the deliberative session as opposed to an open session? What basically guides that?
The wisdom of the board, I think. If a couple of things, you may well have, or a quasi judicial panel may well have multiple applications to consider, and they may not have time to deliberate that evening. Another possible reason to go to deliberative session is if a lot of information has been provided in a hearing and you need time to try to digest it. I'm almost hesitant to point to it, but if it's a tremendously controversial issue, it may be less inflamed conversation to have a deliberative session at a later time. So I don't know if that answers your question, but I'm trying.
Well, no, actually, I mean, that was what I was concerned was probably the likely reason. The other two are interesting and ever, obviously, I don't know any of the mechanics, but you're saying that, that is not really the main function, but it just winds up being, as you said, the common sense of the board to determine whether they want to take it offline or not.
All right. I might try to stop the screen share unless people want to go back to any particular slide. And then I might be able to see what the chat is. I can't see it when I've got screen share going. So anyone mind if I stop the screen share?
No. Go ahead.
All right. Holy smokes, look at that chat. There's 6 questions there. Let's see, what do we have in there? Uh-oh. Laura, yeah, okay. Peter, the slide deck, and Lester, turn off videos. No problem, sir. And here's the Margot posted the link to the survey. Hopefully you can all see that and grab it. It shouldn't take you too long, but we'd very much appreciate it.
Will do.
And I guess that's it. Oh, okay. Well.
Yeah, are you going to send the slides to everyone? Because I'd like a copy as well.
Yep, I will indeed. I'll make a note. Send slide deck. Note with asterisk in the margin. Send slide deck to participants.
And while John's writing that note, you also will receive a copy of the presentation video. So if you want to share it with anybody else on your boards, or you want to rewatch any part of it, you'll have the slide deck as well as the video.
All right, making promises, Margot. I hope we can fulfill.
Well, we've recorded it for a reason.
Yep.
John Bennett's fan club.
Oh, goodness. We'll share video recording. Making a note. See, that's how things sometimes happen if I make a note. If I don't, oh well. It shouldn't be so informal on a recorded presentation. All righty. Well, thank you all.
Thank you, John.
Thank you.
Pleasure indeed.
Really much obliged.
A
All right.
pleasure indeed.